Hello everyone, welcome to Mastermind. In this video, let us continue with our discussion related to Constitution. So this is part 7. So in the part 6, which is the previous part, we have discussed two articles. One is Article 12 and the other one is Article 13. So let us continue our discussion on Article 13. So whatever were the constitutional provisions that we have already discussed, but Article 13 is very important when it comes to our examination. Because the provision of judicial review also comes out from Article 13 for us. We will understand about this thing in a little more detail. Now, when we were looking at Article 13, we saw that the laws which were inconsistent with or in derogation of fundamental rights, they were to be considered as invalid. So in Article 13, we mostly saw about the laws which existed before Constitution came into place. So it was also telling that if any law is there which is there before Constitution came into place, and if that is inconsistent with that of the fundamental rights, then it is to be considered as void. Now, why do we have to consider that? The reason for that is our Constitution came into force on 26th of January 1950. 26th of January 1950. So in this way, even the fundamental rights came into force from this date itself, because before this we did not have constitution as such. That is, even though it was being drafted, we had adopted, it came into force on 26th of January 1950, and hence fundamental rights becomes operative from this particular date only. And because of that only we are speaking about the laws which were before that. Now, what is pre-constitutional laws? That is, the laws before the existence of the Constitution that must provide compatibility with that of the fundamental rights. Now, when we are looking at the Article 13, there are different doctrines which we have to understand. Different doctrines. So, first one is doctrine of separability. So, first one is doctrine of separability. Now, let us assume there is XYZ law. And XYZ has, let's say, 4 provisions: 1, 2, 3, and 4. Now, in this, the provision 3 is inconsistent with fundamental rights. Okay, so we have just taken an example of a law which is XYZ, and in this there are 4 provisions. Now, provision 3 is inconsistent with that of fundamental right. At that point of a time, the whole XYZ itself becomes invalid, or just the provision becomes invalid. Correct? That also has to be a question. So in this doctrine of separability, it says that only the particular clause would be treated as invalid. So in this case, if XYZ is the law and the provision number 3 inside that particular law is inconsistent with that of fundamental rights, then only that particular clause would be treated to be void by the court of law. Okay, so that is doctrine of separability. Under this doctrine, there is an important case which we have to understand. So just remember, it is A.K. Gopalan versus State of Madras 1950. Just understand this case. It is not that important to remember if we just understand what is the actual verdict out of it. So what happened is, there was a Preventive Detention Act of 1950. So under this Preventive Detention Act of 1950, there was section 14. Okay, so this act is very huge. In that, there was one section, And this section 14 said that if any person is being detained under this act, which is Preventive Detention Act, then he or she may not disclose the ground of his detention in the court of law. That is, they would not disclose ground of detention in court of law. Okay, court of law. Now, this is inconsistent with Article 22. So, if you don't know Article 22, don't worry, we will discuss about that in this particular series itself. That is, we have already started discussing about fundamental rights, and there are a few doctrines which will be very, very important for us to remember in case of examination, and that is why in this Constitution series itself I have added the doctrines as well, especially with respect to that of Article 13. There will be lot of times the questions has been asked. Okay, so we'll discuss about Article 22 as well. Just as a brief, I'll tell you what is Article 22. Article 22, there are two clauses. One clause says that any person who is in the custody has to be informed why that person is arrested. That is the first thing. Second one says that the arrested individual should be produced in front of the judicial magistrate within 24 hours. So first one is the reason for arrest. Second one says that 24 hours before which they have to be produced in front of the magistrate. So these are the two provisions which has been mentioned under Article 22. Now section 14, which says that should not disclose the ground in court of law, that is inconsistent with that of Article 22, which is our fundamental right, correct? At that particular point of a time, should we make the whole act invalid or just this section invalid? Correct? If we make the whole act invalid, then that preventive detention itself would come into a question, correct? And hence they would make only the section 14 as invalid. So when we apply this doctrine of separability, here the whole act would not be declared as void, but only section 14 of this act would be declared as void. Okay, I hope you have understood about doctrine of separability. Then there is another doctrine which you have to understand, which is doctrine of eclipse. Now in this case also, in case of doctrine of eclipse, let us consider the same law, which is XYZ. Let us assume that XYZ is inconsistent with that of fundamental rights. It is inconsistent with that of fundamental rights. Then doctrine of eclipse says that XYZ does not completely go off. Doesn't completely go off. That is, it doesn't completely disappear. Similar to that of a eclipse. You can see here the sun's rays are falling on this earth, but this thing completely becomes the umbra area, right? So this is the shadow area. That is, it is not that it disappeared completely. It is there, but it is in the shadow area. It is just in the shadow area. That is, it is eclipsed. It is eclipsed. That is, it doesn't completely become invalid. It is eclipsed. I just had grabbed this image in order to make you understand related to that of eclipse. So what is doctrine of eclipse? It says that whenever any law that is pre-constitutional laws, see, we are discussing about Article 13 subclause 1 over here, and one very important point for you all to remember is that all of these things which we are discussing is applicable only in the pre-constitutional laws, not to the post-constitutional laws. Because for post-constitutional laws, we have Article 13 subclause 2 there. But these are for the pre-constitutional laws. So if there is a pre-constitutional law and that law is inconsistent with that of fundamental rights, then doctrine of eclipse says that it doesn't completely disappear. It still exists. It doesn't completely disappear, but it still exists. That means it becomes inactive. It becomes inactive because in front there will be fundamental rights. So it will become inactive behind. It will become inactive. So when the conflict is resolved, the law can become active again. That is when there can be amendment or required changes which can be made. At that point of a time, it will become active again. So in other words, you can say that the law which is inconsistent is temporarily overshadowed, and when changes are made to that particular law, again it will become active. So I hope you have understood about what is doctrine of eclipse over here. What is doctrine of eclipse over here? So in case of doctrine of separability, what did we see? Only certain provision can be declared as void. In case of doctrine of eclipse, we saw that the law which is inconsistent, pre-constitutional law which is inconsistent with that of fundamental rights, becomes temporarily inactive. It can be made active by having proper changes to that particular law. And all of these are applicable for the pre-constitutional provisions itself, because post-constitution it is guided by Article 13 subclause 2. Now there is a case with respect to this, which is Bhikaji versus State of MP. Bhikaji versus State of MP, 1955. The case was in 1955. What happened is, there was this Berar Motor Vehicle Act. Berar Motor Vehicle Act of 1947, and this was challenged. This was challenged because this act gave monopoly, that is, this authorized the state government to have a monopoly in case of motor business. In case of motor business, it had monopoly. But when the constitution came into place, because this act was before the commencement of the constitution, or before the constitution came into place, it was before that, and hence when the constitution came into place, it became invalid under the Article 19 subclause 1 subclause G. This Article 19 subclause 1 subclause G, it provides a right to practice any profession or to carry any occupation, trade or business to all the citizens. Okay, so that is being provided in that. But in this case, the state will have monopoly, so this act will be inconsistent with that of Article 19 subclause 1 subclause G. Correct? So it has to become completely invalid. But what the government did is, they bought amendment to Article 19. Okay, they bought amendment to Article 19, and clause 6 was added, and then there was this authorization which again restored the monopoly to the government. Okay, we'll discuss about that and in detail about Article 19 also when we are discussing about Article 19, but this is just a case law or an example for you to remember. Okay, so these two cases are very, very important. These two cases relate, these two doctrines, that is doctrine of separability and doctrine of eclipse, are very, very important. Then there is another doctrine, which is doctrine of waiver. Now what is doctrine of waiver? Doctrine of waiver is a situation wherein the person who is having the fundamental right, okay, the person who is having the fundamental right, he voluntarily gives up that right. So the person voluntarily gives up that right or the claim which is related to the right. That is happening by that person because he or she is choosing not to enforce. They are choosing not to enforce a right. The person waives their ability to later assert it. For example, if someone has the right to sue for a breach of contract, there is a contract, and for a breach of contract they can go to the court also, but they will decide not to take the legal action. In that case, they may waive that particular right. So that is called as doctrine of waiver. So these three are very, very important doctrine, and you have to understand about these things. In the next part, we'll start continuing on the articles which we are discussing related to fundamental rights, and the first right which we have to discuss will be Article 14. Let us start from the next part.